Welcome to the training guide on what happens once the unfair labor practice charge form is filed with SERB. There are two phases in this process, the investigation phase and the determination phase. In the investigation phase, first comes the initial review of the charge. SERB is looking to see, was the charge received in a hard copy form? Remember, the ULP charge cannot be filed by email or fax. Was the charge filed within the 90-day time frame requirements? Is the proof of service portion of the charge completely filled out, signed, and dated? If the charge meets these criteria, the investigator assigned to the charge will begin investigating the allegations. Please note, if the charge does not meet these criteria, it will be returned, or the party filing the charge will be requested to clarify the information and the statement of facts. The investigator will next likely request information and documentation from both parties to support their respective positions regarding the allegations made in the charge. The parties will be given a due date to provide the requested information and documentation. Once the parties have provided their information and documentation, the investigator will review it to determine whether there is a probability that the conduct alleged in Box 5, basis of charge, is a violation of Ohio Revised Code Section 4117.11 A or B. After reviewing all of the information and documentation provided by the parties, the investigator might determine that the acts alleged in the charge do not rise to the level of an unfair labor practice and recommend dismissal of the charge. The investigator will then prepare a report containing the factual findings and submit it to the SERB board. Alternatively, the investigator might determine that the acts alleged in the charge may rise to the level of an unfair labor practice. The investigator will then prepare a report containing the factual findings and submit it to the SERB board. The next step is the determination phase. After the board's review of the investigator's report and recommendation, it will determine whether or not there is probable cause that a violation has occurred. If the board finds that there is no probable cause, they will issue a directive dismissing the charge. When the board finds that there is probable cause to believe a violation has occurred, they may order the parties to participate in mediation in an attempt to settle the matter prior to issuing a complaint. If the mediation is unsuccessful, a complaint will then be issued. The complaint describes the acts alleged to be unfair labor practices. Included with the complaint is a procedural order, which sets the date and time for a hearing on the complaint. The charged party must then respond, in writing, either stating admission or denial of the alleged acts or explain their position on each allegation contained in the complaint. The hearing would then be conducted either by the full board or an administrative law judge. Evidence is taken in the form of documents and witness testimony. Once the hearing is complete, the hearing officer will then submit a proposed order to the board for their review. The proposed order contains the supporting findings of fact, reasonings, and conclusions of law. If the board concludes that a violation has occurred, they will impose an appropriate remedy. If the board finds that there is no violation, the complaint will be dismissed. We hope that you have found this training helpful. If you still have questions, please call SERB and ask to speak to an investigator.